City of Akron Law Department versus Mark Baum. It's a Court of Appeals case number 29882. So the City of Akron is submitting their argument on their brief. So we will hear from you for 15 minutes. We have read the briefs and we are prepared to hear from you this morning. So go ahead.
Okay,
Judge Callahan, if you again would keep time for us on this one, please.
I will be keeping time.
Okay, thank you. The reason the decision was made, and I don't feel the lower courts did a thorough examination of the discovery of the billing, and this whole thing could have been avoided. I'm trying to find my notes here. This whole thing could have been avoided by the 919 reading, and it was another 700 cubic feet. That would have lowered. I'm trying to find all my notes here. Sorry. They had a reading that was zero use of consumption, from the point of eviction on 4/2018 to 8/2018, zero read, zero usage. They never billed me during that point in time. There was no consumption, but they knew that the house had a history of stolen water from past tenants, and someone went in there and turned it on inadvertently. On 919, they had a reading of 942 cubic feet, which is a 700 cubic foot consumption. That would have prompted a $7,000 bill to me, and they didn't shut off the water at that point in time. I don't feel they did their job. They did turn it off the next month at 1,800 cubic feet, which, in 2 months they want to basically penalize me $20,000 for this, and they could have stopped it with only 30% of the usage that they claim, because their meter reader didn't want to put an emergency disconnection because of the notice. I never received an email nor a paper mail bill. Otherwise, I would have had it turned off. It might have taken a minute for the bill process to go through. It might have been a week, and I might have been able to stop it at 1,100 cubic feet, not 1,800 cubic feet. In addition, the vast majority of water bills are 80% are for EPA remediation down in the Merriman Valley, the sewer system. And I had no operational drain downstairs. I had a police report stating that my house was vandalized once the tenant moved out, and all the plumbing, any serviceable plumbing, was removed and scrapped, and there was a meter left there, and that's where someone inadvertently or maybe intentionally just turned the water on out of spite, and it went running there onto the floor of my basement with no operational drain. And even if there was an operational drain, people are paying per use for water, and the average amount of human waste that goes in the septic sewer. And if anything, if it did go through any kind of drain in the basement, which was inoperable, then it would just basically been equivalent to a hydrant flushing. And, I wasn't adding any more. It was basically just water draining through. So, I'm willing to meet and pay the water consumption portion of it, but to be penalized for all that sewer, which, cannot prove that the water went through the septic tank. Through the septic system and through the city of Akron. So that's basically the premise of my argument. I'm willing to work with them and pay the water up till the 919, where it should have been turned off. But I guess they didn't want to mediate, and they didn't want to even try before the trial. They didn't want to. I tried to initiate some kind of mediation even then. So we never could even meet in the middle or meet at a fair resolution. So, and all because the lower court decided not to analyze and question the city of Akron about their meter reading technique and why it wasn't turned off at an alarmingly high rate. I mean, I was average consumption when I had the tenant in there was 10 cubic feet, 10 cubic feet a month, it looks like. And if they went up 700 cubic feet, that's like 70 months of consumption. There should have been a big red flag. And that's why I'm hoping that we can make the resolution based on the 9/19/2018 read, because I wasn't notified. Otherwise, I would have had.
Let me ask you this, Mr. Let me ask you a quick question here. The arguments that you're making to the court today, did you make those arguments to the trial court?
I had an attorney take over because things weren't going my direction, and he told me that he would discuss everything with him. And you know what? At that last conference we had, I got nothing from the attorney, and I just kept my mouth shut. That's why I came to appeals court. But I did make that point. It's in the discovery of the file. I did ask them, why wasn't the meter turned off? I got no answer in court. That's why I can't believe that the judgment went that way. If you review the case, you'll see it all. And yeah, they know all the questions I asked in discovery. Basically, why wasn't it shut off at night? And they said that it's all public records, and they didn't give it a reason. I even asked during the last conference with my attorney. I asked the guy in charge of the water supervisor at the water department, Dwayne Smith, I believe his name is, and he couldn't give me an answer. I said, this is over a per phone conversation with him. He couldn't give me a viable answer as to why wasn't this shut off at 942, being 70 times the monthly rate. And I mean, I'm willing to pay that 70 times the monthly rate for the water only, but it just seems to be completely unfair, and how they wouldn't look at it from my perspective. You know, for them, it might be one water bill. For me, it's a huge dilemma. In today's tough times, that's buying a used vehicle that's halfway decent. That's helping my kid through school. That's money I need, and because of their misfeasance, that 942 red, that was, and even in our conference, I think that the judge from the lower court should have asked. My attorney should have asked, but he misrepresented me. So here I am to try and show you, get some answers, and that's why I wanted Miss Smith there. But they had the right to waive their appearance at this. But I wanted to have you hear me answer that question, sir. Go ahead. Sorry.
Sure. The reason I'm asking is, we're limited to what's in the record and the arguments that are made below. So that's what our job is to review those things. And of course, we'll do that in your case, but I'm just not sure how much of this argument that you're making is contained in that record. So that's the only reason I asked the question, just for explanation purposes for you.
Okay. Well, I was just explaining the entire situation to you, and I know it has to be presented in court, but I think that the court should have inferred, and my attorney should have, told the court that, hey, there's a discrepancy on these reads. And I did ask them, and they answered acceptably enough for the judge to render the decision for them, as opposed to asking. That's why, just because the judge didn't analyze the billing, it was there, Exhibit A5, sir. It was there for her to discern too. I presented the data. It was there. So if they didn't analyze all the data, that's why I'm bringing it back. If they just broad brushed as a big pile of papers with a bunch of bills that mean nothing, and it's only 10 pages of real of any intrinsic value whatsoever. And like I said, Exhibit A5 is there in the original case, and that'll show you that if that was analyzed properly, then she would have questioned the plaintiff. And that's why I felt like the judgment was questionable. And I contested the judgment summary based on the fact that there was there were some material questions that needed to be answered, and they was to none of their interest. So that's why I think it doesn't seem to be represented. It may not be represented in the verbiage, but it's there in exhibits, and I'm sure I questioned them on that consumption. I'm sure it's in discovery. Why the lower courts decided not to ask that question in our conference is beyond me too, sir. So that's so there's the facts of the matter. There's the chronological sequence of the order of the billing events, and there's everything was presented to them, and they decided to dismiss all my information and make it seem like a non-issue. Hello?
All right, anything further that you would like to add?
No, I've taken enough of your time. I appreciate you listening to me, and I just want to give a fair shake. I just want to give them a fair amount for the water consumption, and I think that's a fair settlement to ask for. And I appreciate your consideration and listening to my oral argument this morning.
Well, thank you, but let me remind you, you're not taking up our time. You've got 15 minutes, so if you need any additional time, please feel free to use it. It's your time.
Okay, I'm still going. Okay, we're at 12 minutes now. So, yeah, basically, I asked the question about the 919 reading, and I think it should have been immediately shut off at that point. And I had the police report stating that I had no serviceable plumbing, so there really was no sewer usage. The sewer maintenance regards human waste, which there couldn't have been because there was no working commode in the house. And I think that covers everything, sir. I mean, do you guys have any questions for me?
Well, let me see. Judge Callahan, any questions? She's indicating she does not. And what about you, Judge Hensel? Any questions? Okay. She does not. And nor do I. So we want to thank you for appearing today and making your argument telephonically. We will take the matter under advisement, check the record, and issue a decision in due course. Mr. Baum, the court will send you a copy of the court's decision when it is made, and the decisions are also posted on the Ohio Supreme Court's website as well. But thank you for taking the time to appear today.